Now, it's time for Uncancelled, where Britain's top commentators speak out on controversial issues without the fear of the cancel culture sweeping the rest of the media. My guest tonight played an integral role in launching the biggest counter-offensive yet against woke oppression. Leading barrister and libertarian Francis Hoar is the man behind a 50-page report by Laurence Fox's Reclaim Party demanding free speech be enshrined in UK law. In his analysis, Francis calls for a homegrown counterpart of the First Amendment, which will block tech giants from censoring lawful speech and ban police from investigating social media posts and so-called non-hate crimes. The In Protection of Free Speech report has been drawn up in response to the proposed online safety bill, which critics fear will allow the elite to silence views expressed on the web that go against the grain. Censorship is something Francis has experienced himself throughout the pandemic while speaking out against vaccine passports, mask scare tactics and the other infringements on our civil liberties that have shattered our lives. In a stirring segment of the report, he declares the free exchange of ideas is the foundation of all freedom. A person's opinion is a gift to others. Only through openness and the clash of ideas may we enlarge knowledge and understanding to the betterment of mankind. And Francis Hoar joins me now. In fact, Francis, I mean, that's a great description of what we try and do on this show every night. So I absolutely support it. This is it here, the report In Protection of Free Speech. And I have thought for some time we need some legal protections that are enshrined in law in the US via the First Amendment, because especially working as a member of the media, people have no idea the way our wings are clipped on a daily basis because of legal fears, which our counterparts in the US just do not have to deal with.
Yes, and supposedly we have protections through the Human Rights Act, which incorporates into British law, English and Scottish law, Article 10, which is the right to freedom of expression, and that's important, and that is obviously based upon long-standing common law rights and is derived from the English common law and, to an extent, the Bill of Rights of 1689. But, as you say, freedom of speech is under attack, and it just simply isn't sufficient, in my view, to say that because we have these long-standing protections, that freedom, we can assume, will be accepted and will be permitted.
Because we live in a world, Francis, where people are losing jobs on a regular basis now for simply expressing opinions. And views, by the way, which are completely legal. They just go against what the woke corporate elite think. I mean, this is where we're at.
At the launch, it was said that there are something like 600 in the last year or possibly 2 years. And we do actually propose that freedom of speech itself should be protected in employment law. For those who are speaking outside the course of their employment.
Yes.
So obviously we accept that if you're an army officer or if you're a policeman and you can't speak about politics even outside your employment, so there can be exceptions for that. And there might be a reason why you stop political speech inside your employment. You might want to stop people because of controversy, you might want to stop bad feeling, and so on. But if you're making political speech on Twitter, it's simply not good enough to say you have a protection of having a philosophical belief, because sometimes you might be giving a perfectly reasonable or unreasonable speech that is disliked by your employer. It doesn't necessarily mean you have a philosophical belief which is protected by the Equality Act, and then you will not be protected and you will have no comeback and no resource and if you are dismissed.
And we have seen it so much over the past 18 months, haven't we? People like you and people like me who question some of the draconian and authoritarian legal measures that have been introduced to this country on the basis of public health. We've been accused of being irresponsible, or we've been shut down, or the media hasn't reported on what we're saying because of a fear of Ofcom. And actually, I think what it's done is meant that the country has actually never had a proper debate, like a real debate about lockdown and the collateral damage of lockdown. And I'm not saying that I know everything and I'm right, but all I've asked for is a proper debate, and we haven't had it. And I think it shows just how worrying this move towards stopping free speech in lots of settings is, because this has been some of the biggest changes to the law of our times and changes to our civil liberties of our times, and we're still not properly debating it.
The judge in the Court of Appeal giving permission to put our case to a full hearing of the court in last year said these were the greatest impositions on liberty in this country in peacetime, perhaps ever. And he was unquestionably right. Never before have we had freedom of assembly completely curtailed, without exception, according to the letter of the law. Never before have we had anyone being told that every single person in the country, subject to exceptions, must stay in their house, save for limited periods of the day or limited times. Never before have we had whole categories of business closed. And yet we're told that we must believe government public health advice, even though that government public health advice and the model is totally contrary to all precedent in pandemic planning across the world, has never been tried and was just trialled by communist China, and that is where it comes from. So despite that, we've had, as you say, Dan, almost no debate, save on social media, where we have had some debate, but social media companies themselves have been scrupulous in censoring speech. So, for example, if you suggest in a peer-reviewed publication that asymptomatic transmission is minimal and there's very little evidence for it at all, and that's at the foundation of all these measures, the suggestion that you can pass it on if you don't have symptoms, you are censored by Twitter, for example.
Because they'll say it's misinformation.
They'll say it's misinformation.
And likewise, so-called conspiracy theories, which have proven to be anything but about the origins of COVID-19 and whether it actually escaped from that lab in Wuhan, were shut down. The debate was shut down by both social media and the mainstream media. One of the issues is, though, Francis, that the social media companies have operated like the Wild West, and they have allowed so much abuse, lots of illegal abuse, by the way, that the police investigate.
Yep.
And that's why the online safety bill has been introduced by the government. But you say it will actually provide a dangerous imposition on freedom of speech online, because it will impose on social media companies a duty to remove content that could cause harm to an adult of reasonable sensibilities. So I understand that. But the problem is, Francis, how do you rein in and control the Wild West of social media, right? Because it's all well and good to talk about free speech, but what if that involves people posting revenge porn against young people? What if it involves posting bullying of young people? And what if it involves posting things like what J.K. Rowling pointed out and we discussed earlier in the show, someone actually threatening to take her out with a pipe bomb? And the problem is, at the moment, the social media companies do allow all of this to stay up.
All of those are criminal offences. They're a mixture of harassment, the incitement to criminal offences, or other things.
But just because it's criminal, it doesn't mean the social media companies take it down, because I've had this experience myself. They often, even if the police are investigating, even if cases go to court, the social media companies, if these posts do not go against their own internal policies, they will leave them online.
And then, if the social media company is aware of the organic material and hasn't done anything about it, the social media shares responsibility as a publisher with the person who wrote the tweet. And that's important. So, for example, if you report a libel to a social media company and they don't take the tweet down, after a period within which they can investigate, they become the publisher. That's an important distinction. But what this bill requires is for social media to have a duty to investigate, and not to have a duty to investigate crimes. That might be something. Everything you said is a criminal offence. All of them should be taken down. This is to investigate things, whether they or not they are crimes that could cause harm to a person of reasonable sensibilities. So that could involve great literature. You can imagine how much great literature that might involve. But importantly, and I think this is the key, and I think this is why it's being introduced, anything that questions the what is called the orthodox science. But of course, orthodox science is a misnomer, because true science is about argument and discussion and experimentation and discovering what is the truth. There is no such, well, there might be such a thing as truth, but in science, it is about uncovering truth. Science is a process. Science is a debate. Everything should be a debate. And that is what Ofcom bans you from saying on occasion, because there are very strict Ofcom rules on broadcasters about any criticism of public health advice, and it also is applied by Silicon Valley tech companies to restrict any form of debate, or very many forms of debate about this pandemic and about many other things. That's problematic.
Let's bring up in our panel now, Darren Grimes is back, as is Esther Kraku and Becca Hudson too, who is head of digital here at GBNews. Becca, where do you stand on this one? Because, of course, freedom of speech is so important. It's something that we all believe in. But at the moment, the social media companies don't seem to be taking responsibility, do they?
Yeah, I mean, they're having a torrid time at the moment. They can't get anything right. I mean, my question would be, do you not have any concern that the sort of defence of freedom of speech will be used to defend hateful and abusive language, particularly aimed or around kind of protected categories? You know, I could just go on and I could say kind of awful racist things or awful things about the trans community, but then say it's my freedom of speech and get away with it. So how do we stop this becoming a kind of get out of jail free card for truly hateful?
We have criminal offences, and if those criminal offences aren't severe enough, Parliament can debate them and create more criminal offences. If something is a criminal offence, then social media companies, if they want to avoid being a party to that criminal offence, once they're a publisher, can and should remove it. That's the answer. The answer is we decide as a democratic country what the limits of speech is. It's not absolute, of course, because you're not allowed to incite hatred, incite any form of criminal offences, has always been an offence. But if something isn't an offence, you're asking for a decision about something which is totally indeterminate and which Parliament has never decided should be an offence, and we haven't as a community, and asking a social media company to take it down. And that obviously means that there will be huge risks of different standards applied, dangerously disproportionate decisions and so on, and no free speech.
I just wonder, though, if by introducing this concept that you can defend everything as my freedom of speech, we just risk kind of diluting the prosecution process and slowing down the process of getting justice for people who use these platforms for such harmful language and threats and criminality.
I can't see how it would have any effect on that whatsoever, because, again, these are criminal offences. This doesn't change that one bit. The suggestions in this report are simply that social media companies should not be permitted to censor a speech that is not a criminal offence or a civil wrong, such as, for example, libel or breach of privacy, and there are many others.
Darren Grimes?
Well, we're talking about protections there for lawful speech, right? Well, even when your speech is lawful, you can find yourself in trouble, as I well know. The College of Policing's Hate Crimes and Operational Guidance says that recommends the recording of non-crime hate incidents. Now, earlier in this show, we were talking about J.K. Rowling and the fact that actually she caused so-called offence to people online. They could then report her to the police, Francis, and in a sort of true Orwellian fashion, she would be recorded as having a non-crime hate incident against her name. Now, we're talking about the censorship from social media, much of what you've discussed already, but actually, what effect do you think that this recommendation on non-crime hate incidents, and not a lot of people know that these things exist, but they do, folks, I'm not making it up. Do you worry about the repercussions, or do you address this in the report, about self-censorship, where people just say, well, I'm not going to say this because actually, if I do offend someone, then I'll get this non-crime hate incident put against my name. That comes up in deep DBS checks and precludes me from certain employment.
Yes, I do think that's a real problem, which is why we proposed in the report that the online that particular guidance by the police, by the College of Policing, be removed. Now, it might be removed by the courts. Harry Miller's case is before the Court of Appeal, and judgment is due quite soon. and he has a real prospect of showing that that is unlawful. But it should be, and if it's not made unlawful by the courts through a decision, a case law decision, it should be ended by statute. Because, as you say, it's totally Orwellian concept to say that you have a non-crime hate or a hate non-crime incident. With all sorts of things might be hateful, but we do have actually a relatively low threshold for lots of comments online. Grossly offensive comments can, in certain circumstances, if made online or in a communication, be unlawful, and that goes quite far. But we need to have a robustness, I think. That is, it's very difficult when you have a society that's so worried about its own safety and so concerned to be cocooned that it isn't exposed to robust debate. Mm-hmm. And in fact, as Mr. Justice Knowles, I think, in that judgment in Miller said, the Harry Miller case, and this goes back to long common law traditions. Free speech involves unpleasant speech. It involves speech that people don't want to hear. Great controversies. Otherwise, Galileo. We're back in the situation of Galileo, where the uncomfortable, heretical view that the Earth travelled around the sun wasn't allowed to be spoken about, and that's an extreme. But is it such an extreme when you have scientific opinion and scientific debate is censored by social media companies, and also, in fact, your particular example, biological facts, which cannot be spoken about, or if they are spoken about, are supposedly a non-crime hate incident.
Indeed, Francis Hoar, thank you so much. Welcome to the GB News YouTube channel. You can watch us live 24 hours a day, catch up on your favourite shows, and join in the conversation in the comments below.
Don't forget to subscribe and you'll never miss any of our exclusive content.